In this video, we will discuss and define prospectivity and retroactivity. This is very basic but important topics in criminal law. So let's start the discussion. We will define first the meaning of prospectivity and retroactivity. So prospectivity is the third characteristics of criminal law. In this principle, our criminal law merely punishes crimes committed on or after its effectivity, and it cannot make an act punishable a manner in which it was not punishable when committed. For example, the law that will define and punish person who will post hugot lines in Facebook enacted on July 1, 2021. This is just an example, okay? So it means if we follow prospectivity principle, the effectivity of that law will also start on that day, which is July 1, 2021, and it cannot affect the previous actions even though it is a crime under that law, because at that particular time, that law is not existing. So legally speaking, our law looks forward in prospectivity principle. As you can see in the definition, we can see the terms on or after its effectivity. So it means in prospectivity, our criminal law is forward-looking. On the other hand, retroactivity is an effect of law that will look backward or contemplates the past affecting acts or facts that existed before the act came into effect. I'm sure you notice that prospectivity and retroactivity are opposite to each other. Yes, that's true. In retroactivity, it is backward-looking, while in prospectivity, it is forward-looking. So in retroactivity, it will affect the previous actions even before the passage of the statute. We already discussed about ex post facto law in our previous video, so in some instances, if we will give retroactive application in criminal law, it will acquire the characteristics of an ex post facto law. That's why, as a general rule, our law is not retroactive, it is prospective to avoid an ex post facto law, because as what I've discussed in my previous video, ex post facto law is unconstitutional. In Article 344 of the Revised Penal Code, crimes are punished under the law in force at the time of their commission. So if we analyze this provision, we can say it is referring to prospectivity principle. I will give you a very important Latin maxim which is related to this topic. We have the maxim lex proslicet non respice, or in English, the law looks forward, not backward. It means our law is not retroactive, it is prospective as a general rule. As what I've said earlier, our criminal law is prospective, not retroactive as a general rule. It means we have exemptions to this rule. We can give retroactive application in these three instances. First, if it is favorable to the accused who is not an habitual delinquent. For example, the convict is already servicing his sentence by final judgment of the crime murder. Then the Congress passes a law that will reduce the penalty of murder from reclusion perpetua to arresto minor. So we can apply retroactivity because the law is favorable or lenient to the accused even though final judgment is already pronounced. But the convict must not be an habitual delinquent. If the contrary is an habitual delinquent, then he is not entitled with the repealed law. Second, decriminalizes an act. For example, based on the record, RA number 10158 decriminalizes vagrancy under Article 202 of the Revised Penal Code, since vagrants as victims of poverty should be protected rather than punished. And third, if the law expressly provides retroactivity. We all know that Congress as a legislative branch has a power to insert some provisions under the law. So if they inserted a provision under a law that will say retroactive application is allowed, then it will fall under this exemption.